I was contacted, it's hard to remember, probably about 5-6 weeks ago with the request that I do a critical analysis of the practices and procedures of JCS as they related to the work with the Municipal Court of Harpersville. And I did lay down those conditions Mr. McMichaels had said, that I had really no knowledge of JCS, had never worked with it, never had any relationship with it in the past, had no relationship to any of the lawyers that were involved in the ongoing litigation, and that if I was asked to do a review and furnish an opinion, they would get my honest and impartial opinion, and that any remuneration that I was charging for the time and effort I put into that would not be conditioned upon the outcome of my findings. So I undertook that responsibility to determine to the best I could what were the responsibilities and duties and obligations of Judicial Correction Services, or as it's easier to refer to it by way of shorthand, JCS, with respect to the policies and practices of the Municipal Court of Harpersville. And in that regard, I was guided by the client agreement which had been entered into between Harpersville and JCS, the probation orders which the municipal judge, in this case Judge Larry Ward, would issue with respect to any probation assigned to JCS, the statutes passed by the Alabama legislature that relate to the jurisdiction and duties and conduct of a municipal court, certain case law from the Alabama Supreme Court, and opinions of the Attorney General of Alabama. The Alabama statutes in Chapter 14 describe the jurisdiction, the authority, the duties and responsibilities of municipal courts and the judges and magistrates who serve those courts. The Alabama Supreme Court, in a 1996 opinion styled Wilkins versus Dan Haggerty and Associates and the City of Mobile, and a unanimous opinion of all the justices, ruled that a municipal court could legitimately and properly under Alabama law enter into a contract with a private company to collect municipal court fines and costs, and could add a fee onto that, a contingent fee for those collection services. More to the point, in 1998, the Alabama Attorney General, then Bill Pryor, now a federal circuit judge, issued an opinion upon request from a municipal judge that stated that it was also appropriate for municipal courts and the municipalities that ran those courts to enter into private agreements with private probation companies in order to supervise and provide probation services that the municipality might otherwise provide. That 1998 opinion by the Attorney General was reaffirmed in 2001 by another opinion the Attorney General issued. So against that backdrop, I undertook to review the order that Judge Hub Harrington had issued in the case that was ongoing with respect to the town of Harpersville and JCS. That was his order of July 11, 2012. And let me say at this point that I'm in no way here to try to question or certainly presume to contradict anything that Judge Harrington ruled or held. He is a well-respected jurist. He is a judge of great experience and a very able judge. So I am not here in my capacity as sort of second-guessing anything in that order. And let me also point out that although I certainly am proud of my long career of 50 years in the practice of law, which has involved several services as a judge of one sort or the other, I have no illusions that I'm still a judge. My wife reminds me of that quite frequently. And so I want you to understand that I'm not here presuming to think that I, as Bernard Harwood, have any authority to make any pronouncements that have any weight or any authority. Rather, based on my experience, I felt that I was qualified to do this review and give JCS my unvarnished opinion about how the various matters that Judge Harrington identified in his order might relate to JCS. Judge Harrington identified 12 categories of circumstances that he said were the most egregious, he felt, of the violations of people's rights that he discerned from reading the information available to him in that particular court case. So I have taken those 12 items and have gone through the Alabama statutes, the Alabama case law, and in particular I have relied on the sworn deposition testimony that's been given in the Harpersville case by first Judge Larry Ward, the municipal judge, secondly 2 separate depositions given by Magistrate Penny Hall, the town clerk and magistrate of that court, and then a deposition by Mr. Kevin Egan of JCS. And those sworn depositions and the various documents I had available to me, and then also the pleadings and various submissions that are in the court file that I reviewed, detailed for me and gave me an explanation of how the municipal court of Harpersville conducted various stages of its procedures, including the placing of people on probation. And in that regard, I would say it's important to remember that JCS does not become involved in any municipal court case unless and until the municipal judge, in this case Judge Ward, has signed a probation order. That is the order of the court that then instructs JCS what it is to do as to a particular probationer. So based on all of that, I concluded, as is sort of summarized on these 2 poster boards to my right and left, concerning the activities that Judge Harrington was concerned with and the role and responsibility and involvement of JCS in any of those, as I found it to be from doing that full study. It was clear that in some instances the matters could only be referred to the municipal court and to its personnel. For example, Judge Harrington was concerned about the fact that people would be put into community corrections work, and as he described it, they would be held interminably in county work release programs. Well, the evidence and testimony in this case is clear that a defendant is only put into work release once they've been incarcerated by an order of the municipal court. The testimony was also clear that once the judge has incarcerated somebody, JCS is out of the picture, as they explained it. JCS stops charging any fees at that point. It has no supervisory rights or responsibilities with respect to the probationer, and it is the municipal court of Harpersville which decides in that instance whether or not someone who's incarcerated should be released into a work release program. But again, the testimony was clear that once a defendant is placed in work release, JCS has no involvement, no responsibility, no control over that situation. It receives none of the money that might be earned by an individual in the work release program, nor does it have any rights of supervision of that individual. So of all of the 12 items that Judge Harrington spoke to, I analyzed the law, I analyzed the facts, and concluded, as summarized on these various poster boards, that actually JCS did not have any legal liability or responsibility for those particular items. And that was essentially the result of my research. After that, JCS apparently welcoming my findings, although they did not know in advance what they would be, asked if I would appear here today and participate in this press conference, which I'm willing to do. And I think rather than just go on and on and on as we lawyers do, because I recognize I'm in a profession where what we call a brief may be 300 pages. So I think I'll stop at this point and simply say, if you have any questions, I'll be happy to respond to them. I will emphasize in closing my remarks that the scope of my assignment was very limited. It was to see what is the role and involvement of JCS in any of these areas that Judge Harrington was particularly critical of. It was not to try to cast blame on the Municipal Court of Harpersville or Judge Ward or Magistrate Hall. On the other hand, it was unavoidable to differentiate under the statutes and case law and the contracts and probation orders what are the responsibilities and duties of the municipal court and what are the separate responsibilities and duties of the town of Harpersville. Additionally, I stayed away scrupulously from opining in any regard about the complaints and contentions made by the individual 4 plaintiffs in that Harpersville case. It is certainly not my prerogative to intrude into an ongoing litigation and start having opinions about the merits or demerits of any particular plaintiff's claim. So I have dealt with this from a global point of view, that is taking the testimony of Judge Ward and Judge Hall, where they explain here's how we operate, here's how things are done, applying those to the statutes, and then seeing under each instance what might be the involvement or responsibility, if any, of JCS. So I think I'll conclude my remarks with that. If there are any questions, I'll be happy to attempt to respond. And certainly let me say I don't encourage questions.
This might be a little impolite, but are you getting paid for this?
I certainly am. I am in private practice now, and I charge an hourly rate anytime anyone undertakes to hire me. In fact, in this case, when I was told about what the volume of material might be that I was asked to review, I explained, look, I'm going to have to do working nights and weekends. I'll do a crash course on this and make sure I put in the time and effort that's required, but you will certainly be paying for my time. I did emphasize to them, I said, now you're not paying for my opinion. That will come as however I determine it to be, and I want you to understand whether you're happy or unhappy with my opinion, you're paying for the time I will have invested in it to do that.
So did you review any of the depositions from the plaintiffs?
I did.
I'm just a little confused why, like, explain again what they had to say in those depositions, how those things factored into your report. You're saying that they didn't factor it at all, or?
Really, I tried to exclude that because you've got factual disputes in some instances. You've got some testimony that's not entirely clear about situations. I wanted to read all that so I'd be fully informed about the backdrop, but then like sort of a mule with blinders, I said, I'm going to focus just on what Judge Ward and Judge Hall said. Here are our policies and procedures, our arrangements with JCS. Here's where JCS is involved. Here's where JCS's involvement stops. They were very clear about that. These are the instances where JCS is not involved at all. For example, there was some criticism about jail fees being imposed on the fines and court costs. And Judge Ward and Ms. Hall were very clear, JCS has nothing to do with that. We are the ones who make the decision whether to impose or add jail fees on top of fines and costs. None of that money comes to JCS. So that was a circumstance where I absorbed the information but did not incorporate it into my report because Judge Harrington didn't address that as one of the 12 issues.
I have a question. Did you address the actual probation fees themselves? Because there were complaints that people who were already indigent had these court fines, but then they were also being asked to pay an additional fee every month until the court fee was paid off, which kind of put them in a cycle that they never really could get out of.
I did look at that. Here's what I found. The fees were $35 per month at one point, increased to $45 a month, and in each instance there's a probation order signed by the municipal judge saying you will pay this probation fee in this amount. So it is the judge's order that sets that fee and authorizes its payment to JCS. Judge Ward was very clear, and the records also supported this, that any time he determined anyone was having difficulty in paying, could not pay because of financial hardship, he would direct JCS, quit collecting any fee. He said that after he had done that as sort of a first line of cutting back on the financial obligations, if they still had difficulty and couldn't pay, he would then remit or cut back on the fine and the court costs. Only a municipal judge can declare someone indigent. A private probation officer or even a probation officer. When I was a circuit judge for 10 years, I was blessed to have a series of very good probation officers serving the court at which I presided over. And those probation officers had no authority whatsoever to say, okay, I determine you're indigent, I'm going to cut the fines or this or that or the other. Judge Ward was also very clear that any time someone was reported back to him as not paying the fines and fees and court costs, he would do a very thorough investigation and inquiry with that person. Why can't you pay? What do we need to help you with? Can we cut back on this? And I mean, this was very explicit in his deposition testimony. So the determination of are you able to pay? If not, what relief should be given is assigned under the statutes and under the probation office orders to the municipal court judge.
Who gets paid first when a defendant comes forward with the money to pay a fine but doesn't have enough? Let's say they have $300, fine's $300, but they have a $35 or $45 fee on top of that. Who gets paid first?
The best I could determine from the records and then the testimony of Judge Ward and Ms. Hall and Ms. Deegan was inconclusive about that. What I could determine from that small amount of testimony where they addressed it and the records available to me is that in no instance does JCS like take its fee off the top. In other words, in no instance does JCS say, well, you've paid $100, we have a $35 or $45 fee for this month, so we're going to take it out front, and then the rest of it we'll remit to the court. Rather, they would take some percentage or some portion. In many instances, they collected no fee. I would see records where over the course of time, fines and costs were including as defendants were continuing to be back and forth into the court, and their fee had stopped in the amount that had accumulated at that time. I remember one was $180 was the total of their fees, and it stayed the same for many, many, many months. They just quit charging a fee.
Did you find in any instance that JCS either through letter or verbally threatened defendants with jail time if fees weren't paid? Or?
I found that there was the only letter that's in the court file materials is one letter. I can remember it was Exhibit 31 in all the materials that were produced, written to one of the plaintiffs in this case, who is a defendant in the municipal court. Again, in the interest of privacy, I won't mention that particular defendant's name, but the evidence showed that a letter was issued to her which had language in it that I would call problematic. In other words, if someone asked my opinion, I'd say, I think you've overstated what should be in the letter. I appreciate that a letter ought to be concise, it ought to be compact, you need to get your message across, and if you go on through all of the possible scenarios, you lose the import of the message. But in that instance, the statement was made, if you fail to appear in court, a warrant will issue for your arrest. Under the circumstances I found to be the unvarying policy of the town of Harpersville, that was an accurate prediction. If you did not appear in court after being summoned to court, after you had failed to appear before your probation officer, so this was not just you didn't appear, the probation officers, you haven't appeared before the probation officer. The probation officers reported it back to the court. The court has now set a court date for you to come and explain yourself. If you did not show up for that, the court invariably issued a warrant for your arrest. So that was certainly an actual prediction of what would happen. But if you wanted to be completely accurate, recognizing that it's exclusively the jurisdiction of that trial court to decide whether they're going to place somebody in jail or not, you could have said, if you fail to appear in court, it is likely the judge will issue a warrant. I mean, judges always have the discretion to do what they're going to do, but nonetheless, that was a reasonably accurate prediction to the individual of what's likely to happen if you don't appear in court.
Who writes those letters and how are they formulated? Or is it a form letter that goes out to, I mean, it seems like that these sorts of instances would repeat themselves and you would use the same form over and over again, or I may just be.
Yes, there is a training manual that was offered as an exhibit in the case. I read that thoroughly, the JCS training manual, and it does have a whole lot of decision tree progressions if someone doesn't pay, or if they don't call in, or if they don't report, or here are the different steps to go through, here are letters to write. And so there were a number of formalized letters for those situations.
One of the strongest statements Judge Harrington made in one of his summer orders was comparing the activity at the Harpersville Municipal Court to, quote, a debtor's prison. Based on your review of the facts, what is your reaction to that characterization?
My reaction is I'm going to stay completely away of any sort of characterization of the Harpersville Municipal Court. As I say, my sense of how I could appropriately function in this matter was to say, all right, let me take every one of Judge Harrington's criticisms, let me apply them to to JCS, and identify for myself under all the information available to me, what was JCS's duty, responsibility, or involvement in any way in this particular item of criticism. And so, for example, where community service work or work release was highly criticized, I could readily determine from reading all of that, JCS is out of the picture by the time any of that happens. So to the extent that the role and activity of the town of Harpersville involved, I basically stay away from that. Now, it's necessary for me to differentiate between what the statutes and what the orders of probation say that the town of Harpersville Municipal Court itself will assume responsibility for, and what might be assigned to JCS. So to that extent, I had to find out what is the Harpersville Court doing in these various areas. But as far as then offering an opinion about right or wrong, I would stay away from that. That would be one of the issues in the court and the case to be decided by Judge Harrington.
So there are two judges here in Harpersville. There's Ward and Hall, correct?
Well, Judge, excuse me for interrupting.
Sure.
My wife sometimes says I do, and I said, no, I didn't. I sensed you were ready for my answer. Judge Hall is a magistrate judge, and the Code of Alabama spells out that municipal courts may also have magistrates who are assigned a variety of judicial functions. Many of them they have to do under the direct orders of the judge. Many of them they independently can do on their own, such as setting bail in certain instances. So it is proper to refer to a magistrate as Judge Hall, but they are a magistrate judge as opposed to a municipal judge. So you have one municipal judge and two magistrate judges for the town of Harpersville.